Part 5. Claims and Actions. Article 19. Notice of loss, damage or delay. 1. Unless notice of loss or damage, specifying the general nature of such loss or damage, is given in writing by the consignee to the carrier not later than the working day after the day when the goods were handed over to the consignee. Such handing over is prima facie evidence of the delivery by the carrier of the goods as described in the document of transport or, if no such document has been issued, in good condition. 2. Where the loss or damage is not apparent, the provisions of paragraph 1 of this article apply correspondingly if notice in writing is not given within 15 consecutive days after the day when the goods were handed over to the consignee. 3. If the state of the goods at time they were handed over to the consignee has been the subject of a joint survey or inspection by the parties, notice in writing need not be given of loss or damage ascertained during such survey or inspection. 4. In the case of any actual or apprehended loss or damage, the carrier and the consignee must give all reasonable facilities to each other for inspecting and tallying the goods. 5. No compensation shall be payable for loss resulting from delay in delivery unless a notice has been given in writing to the carrier within 60 consecutive days after the day when the goods were handed over to the consignee. 6. If the goods have been delivered by an actual carrier, any notice given under this article to him shall have the same effect as if it had been given to the carrier, and any notice given to the carrier shall have effect as if given to such actual carrier. 7. Unless notice of loss or damage, specifying the general nature of the loss or damage, is given in writing by the carrier or actual carrier to the shipper not later than 90 consecutive days after the occurrence of such loss or damage or after the delivery of the goods in accordance with paragraph 2 of Article 4, whichever is later. The failure to give such notice is prima facie evidence that the carrier or the actual carrier has sustained no loss or damage due to the fault or neglect of the shipper, his servants or agents. 8. For the purpose of this article, notice given to a person acting on the carrier's or the actual carrier's behalf, including the master or the officer in charge of the ship, or to a person acting on the shipper's behalf, is deemed to have been given to the carrier, to the actual carrier or to the shipper, respectively. Article 20. Limitation of actions. 1. Any action relating to carriage of goods under this convention is time-barred if judicial or arbitral proceedings have not been instituted within a period of 2 years. 2. The limitation period commences on the day on which the carrier has delivered the goods or part thereof, or, in cases where no goods have been delivered, on the last day on which the goods should have been delivered. 3. The day on which the limitation period commences is not included in the period. 4. The person against whom a claim is made may at any time during the running of the limitation period extend that period by a declaration in writing to the claimant. This period may be further extended by another declaration or declarations. 5. An action for indemnity by a person held liable may be instituted even after the expiration of the limitation period provided for in the preceding paragraphs if instituted within the time allowed by the law of the state where proceedings are instituted. However, the time allowed shall not be less than 90 days commencing from the day when the person instituting such action for indemnity has settled the claim or has been served with process in the action against himself. Article 21. Jurisdiction 1. In judicial proceedings relating to carriage of goods under this convention, the plaintiff, at his option, may institute an action in a court which, according to the law of the state where the court is situated, is competent and within the jurisdiction of which is situated one of the following places: the principal place of business, or, in the absence thereof, the habitual residence of the defendant, or b. the place where the contract was made, provided that the defendant has there a place of business, branch or agency through which the contract was made, or c. the port of loading or the port of discharge, or d. any additional place designated for that purpose in the contract of carriage by c. 2. A. Notwithstanding the preceding provisions of this article, an action may be instituted in the courts of any port or place in a contracting state at which the carrying vessel or any other vessel of the same ownership may have been arrested in accordance with applicable rules of the law of that state and of international law. However, in such a case, at his choice, to one of the jurisdictions referred to in paragraph 1 of this article for the determination of the claim. But before such removal, the defendant must furnish security sufficient to ensure payment of any judgment that may subsequently be awarded to the claimant in the action. b. All questions relating to the sufficiency or otherwise of the security shall be determined by the court of the port or place of the arrest. 3. No judicial proceedings relating to carriage of goods under this convention may be instituted in a place not specified in paragraph 1 or 2 of this article. The provisions of this paragraph do not constitute an obstacle to the jurisdiction of the contracting states for provisional or protective measures. 4. A. Where an action has been instituted in a court competent under paragraph 1 or 2 of this article, or where judgment has been delivered by such a court, no new action may be started between the same parties on the same grounds unless the judgment of the court before which the first action was instituted is not enforceable in the country in which the new proceedings are instituted. b. For the purpose of this article, the institution of measures with a view to obtaining enforcement of a judgment is not to be considered as the starting of a new action. c. For the purpose of this article, the removal of an action to a different court within the same country, or to a court in another country, in accordance with paragraph 2 of this article, is not to be considered as the starting of a new action. 5. Notwithstanding the provisions of the preceding paragraphs, an agreement made by the parties after a claim under the contract of carriage by sea has arisen, which designates the place where the claimant may institute an action, is effective. Article 22. Arbitration 1. Subject to the provisions of this article, parties may provide by agreement evidenced in writing that any dispute that may arise relating to carriage of goods under this convention shall be referred to arbitration. 2. Where a charter party contains a provision that disputes arising thereunder shall be referred to arbitration, and a bill of lading issued pursuant to the charter party does not contain a special annotation providing that such provision shall be binding upon the holder of the bill of lading. The carrier may not invoke such provision as against a holder having acquired the bill of lading in good faith. 3. The arbitration proceedings shall, at the option of the claimant, be instituted at one of the following places: a place in a state within whose territory is situated the principal place of business of the defendant, or, in the absence thereof, the habitual residence of the defendant, or the place where the contract was made, provided that the defendant has there a place of business, branch or agency through which the contract was made. or the port of loading or the port of discharge, or b. any place designated for that purpose in the arbitration clause or agreement. 4. The arbitrator or arbitration tribunal shall apply the rules of this convention. 5. The provisions of paragraphs 3 and 4 of this article are deemed to be part of every arbitration clause or agreement, and any term of such clause or agreement which is inconsistent therewith is null and void. 6. Nothing in this article affects the validity of an agreement relating to arbitration made by the parties after the claim under the contract of carriage by sea has arisen.